Next speaker is Professor Lan Nguyen. Professor Lan Nguyen joined the faculty of the law school at Utrecht University 2017. Professor Lan Nguyen holds PhD from University of Cambridge. Professor Lan Nguyen will deliver her presentation entitled Jurisdiction and Applicable Law in the Settlement of Marine Environmental Disputes. Professor Lan Nguyen, you have the floor.
Thank you very much, Mr. Chair, and good morning from Europe. I'd like to first start by expressing my thanks to the organizers for the kind invitation. This is the first time that I'm attending the conference for the law of the sea, so I'm very excited to be a part of this very exciting conference. And I would also like to particularly thank the staff members for their diligence and patience in corresponding with me, and I assume all the other speakers over the past few months in preparation for this conference. So thank you very much. As you can perhaps see from the slides, the topic that I will be presenting today is jurisdiction and applicable law in the settlement of marine environmental disputes. And the reason that I thought this topic would be interesting for discussion is that, as mentioned by Judge Pat yesterday, and as we all know, UNCLOS is a framework agreement. And even though it devotes an entire Part 12 to the protection of the environment, in essence, this Part 12 still contains mostly general obligations, and therefore the content of the various provisions of Part 12 still need to be interpreted and given meaning to. And then if you look at the preamble of the convention, you also see that it says that the problems of the ocean space are closely interrelated and need to be considered as a whole. So this, in my view, calls for the provisions on the protection of the marine environment in Part 12 and the convention as a whole to be interpreted not in isolation, but in fact in harmony with other rules of international law. However, as we are speaking in a panel on dispute settlement, so the question is, when a dispute concerning the marine environmental protection is brought before an international court and tribunal, what happens? So in my view, the holistic approach to interpreting the provisions of Part 12 would still be required. But when we talk about courts and tribunals, and especially courts and tribunals that are specified in Article 287 of UNCLOS, so the courts and tribunals that operate within the parameters of Part 15 of the Convention on Dispute Settlement, it is important to bear in mind, I think, the jurisdictional limits of these tribunals. And this jurisdictional limit is found in Article 288, paragraph 1 of the Convention, which stipulates that courts and tribunals under the convention, so that's including the International Tribunal for the Law of the Sea, the Annex 7 arbitral tribunals, they only have jurisdiction over dispute concerning the interpretation and application of the convention. So this means that UNCLOS tribunals, they are not courts and tribunals of general nature. They are specialized dispute settlement bodies, and therefore they are restrictions on their scope of jurisdiction. However, specialized doesn't mean self-contained. So when a dispute concerning environmental dispute settlement is brought before a court or tribunal under Part 15, these courts and tribunals have to navigate between, on the one hand, the need to interpret Part 12 in a holistic manner, and on the other hand, remaining within the jurisdictional limits that are set by Article 288, paragraph 1. So against that background, what I would like to do today is to firstly look at some of the cases in which courts and tribunals, and I call them unclassed tribunals, have resorted to external sources. Look at the techniques that they have used to resort to external sources, by which I mean the sources or the rules and the norms that are not found under the convention, and assess whether in the course of doing so they have remain within the jurisdictional limits as set out in Article 288, paragraph 1. And in this presentation, I will only focus on the International Tribunal for the Law of the Sea, ICLS, and Annex 7 arbitral tribunals, simply because to date, the cases that are brought under the auspices of Part 15 have only been brought to these two particular dispute settlement bodies. And then finally, I would say a few words on the implications of resorting to external sources on the settlement of marine environmental disputes. So as I said, unclosed tribunals only have jurisdiction to settle disputes falling within the convention. However, once jurisdiction is established, there are several legal bases for these tribunals to resort to sources that are not found under the convention. And some of the ones that are worth mentioning would be, firstly, I think the most obvious candidate is Article 293 of UNCLOS, which is entitled Applicable Law. And as you can see from the wording of this particular paragraph, the court and tribunal has the power to apply not only the convention, but also other rules of international law not incompatible with the convention. The other technique, which was briefly mentioned, I think, by Judge Pak in his keynote speech yesterday, is what is known as the rule of reference. This term, rule of reference, is not used as such, so you will not find the term rule of reference under the convention itself. It is but an umbrella term, if you will, to refer to cases or to refer to instances in which external rules and norms and standards are brought into the convention or are incorporated into UNCLOS on the condition that they reach the threshold of what is known as generally accepted international rules and standards. So here you can see this is an example from Article 211 of UNCLOS, excuse me, relating to vessel source pollution. So this rule of reference is found quite abundantly in Part 12 of the convention. And then, of course, there's Article 31, paragraph 3 of the Vienna Convention on the Law of Treaties on treaty interpretation. And as we all know, this particular paragraph allows for or requires taking into account subsequent agreements, subsequent practice, or any relevant rules of international law applicable to in the relations between parties. So these are some of the legal bases by which UNCLOS tribunals could use to refer to rules and norms that are not found under the conventions to settle disputes falling within the convention. So in practice, UNCLOS tribunals have used one or more of these techniques in deciding several environmental disputes. And in the interest of time, I will only mention a few instances which I think raise interesting points for discussion. Perhaps the South China Sea arbitration would be a good point for departure because in my view, it is one of the first cases in which the provisions of Part 12, several provisions of Part 12 are dealt in such a detailed manner. And so in this particular arbitration, the Philippines brought alleged that China had violated several provisions under Part 12 concerning the interpretation, concerning the protection of the environment, including Articles 192 and 194, paragraph 5. We've heard quite a bit about Article 192 over the past 2 days. The tribunal, in addressing Article 192, said that it imposes a duty on state parties and the content of which is informed by other provisions of Part 12 and other applicable rules of international law. So then on this basis, the tribunal then said that the tribunal used the tribunal held that the obligation under Article 192 is an obligation of due diligence, and therefore, in interpreting Article 192 and Article 194, paragraph 5 of the Convention, the tribunal would resort to other treaties that are such as the CBD or the CITES, so the Convention on the Protection of Endangered Species of Wild Flora and Fauna. So here, by using the due diligence concept, the tribunal opened the gateway for the resort to other treaties. In particular, the tribunal used Article 2 of the Convention on Biodiversity, CBD, which contains a definition of ecosystem. And it also referred to the appendices of the CITES listing endangered species to find that the area in question was indeed constituted rare and fragile ecosystem. So the tribunal, in referring to the CBD as well as the CITES, mentioned Article 237, as well as Article 293, paragraph 1 of UNCLOS, and Article 31 of the VCLT. Particularly in the award on jurisdiction and admissibility, the tribunal explicitly stated that it is the use of Article 293, paragraph 1 of UNCLOS and Article 31, paragraph 3 of VCLT that enabled the tribunal to resort to the CBD. Although these are the provisions that the tribunal invoked explicitly, I think it's worth mentioning that it is the concept of due diligence that really laid the ground for the tribunal to resort to the external sources. In terms of the rule of reference, again, in the South China Sea arbitration, when interpreting Article 94, paragraph 5 on flag states' duties, the excuse me, the arbitral tribunal referred to the COREX, the Convention on the Prevention of Collision at Sea. And here, the Article 94, paragraph 5 itself contains the rule of reference. And here, the tribunal considered that COREX met the threshold of generally accepted rules and standards because it was widely ratified, it was widely accepted, and it is one of the most widely accepted conventions in the world. So therefore, according to the tribunal, COREX met the threshold of the rule of reference, and therefore in interpreting and applying Article 94, paragraph 5 of the UNCLOS, the provisions of COREX had to be taken into account in order for the tribunal to deal with the Philippines Submission 13. In terms of Article 31, paragraph 3 of the VCLT, as I mentioned, the South China Sea arbitration explicitly mentioned Article 31. However, I think there is another case in which Article 31, paragraph 3 might have potentially been invoked, but was not done so in an explicit manner, so to speak. And that is the advisory opinion on IUU fishing, in which the ICLS was asked to interpret flag states' obligation to ensure that the vessels flying their flags do not conduct IUU fishing in the EEZ of another coastal state. So in essence, the tribunal was interpreting Articles 91, 92, 94, 192, and 193 of the convention. And the tribunal found that the coastal states have, the flag states have an obligation to ensure. And the content of these obligations to ensure the tribunal elaborated on. And the tribunal emphasized that these obligations are found or are interpreted based on the wording of the provisions within the framework of UNCLOS itself. However, I believe that a lot of these obligations were actually read into the convention, into these provisions, based on the obligations that are found in subsequent instruments relating to fisheries, such as the 1995 Fish Stocks Agreement, the Compliance Agreement, or other instruments, soft law instruments from the Food and Agriculture Organization relating to IUU fishing. So it seems that here the tribunal was actually relying on Article 31.3 VCLT without acknowledging it. And I think it's worth, and it's interesting, I think, to note in this respect that in his separate opinion to this advisory opinion, Judge Pak was quite critical of the tribunal for not acknowledging the legal basis for resorting to other subsequent agreements. And he instead proposed that the rule of reference could be used to read into the convention flag states obligations in obligation to insure. And I think the proposal of Judge Pak has a lot of merits in the sense that it provides a legal basis for resorting to subsequent agreements. However, I think there's also something that needs to be borne in mind is that the rule of reference is not provided for in a lot of provisions relating to flag states obligation concerning the protection of living marine resources, and therefore there has to be some sort of caution in extending the rule of reference to provisions which do not contain it. So taking stock of what I've discussed so far, I think there are two groups of techniques that allow UNCLOS tribunals to resort to environmental rules and norms that are beyond the convention. And I would roughly classify them as the internal and the external mechanism. And the internal mechanism would be Articles 237, as mentioned in the South China Arbitration, Article 293, paragraph 1, and the rule of reference. The external mechanism is Article 31, paragraph 3 of the VCLT. And importantly, the use of these articles were tied with the concept of due diligence. So the reference to external sources, to external rules and norms is, of course, not peculiar or unique to UNCLOS tribunals. Courts and tribunals do this all the time. And there is nothing inherently problematic about the use of external resources to settle disputes falling within a particular framework. This only becomes problematic if the line between jurisdiction and applicable law is blurred. And there have been cases in the past by the ICLS and Annex 7 Arbitral Tribunal in which this line was actually being blurred. However, looking at the jurisprudence, or at least the few cases that we have looked at so far, it seemed that there has been no conflation between jurisdiction and applicable law. The external sources were used by the tribunals to settle disputes that turned on the interpretation and application of specific provisions of UNCLOS, so disputes falling squarely within UNCLOS. So in that sense, I think the line between jurisdiction and applicable law has been respected. So coming to the last point, what are the implications of using external sources in deciding disputes falling within the UNCLOS? I think there are two groups of issues that can be raised here. The first is the use of external sources in interpreting obligations under the convention. On the positive side, ensures that UNCLOS is interpreted in harmony with the developments of international law. And Judge Haida has already mentioned that UNCLOS, and particularly Part 12, is a product of the 70s. So using reference to external sources will allow UNCLOS to develop with new, to be able to deal with new challenges and to stay relevant to the protection of the marine environment in modern day. Also, the Article 31, paragraph 3 of the VCLT has been considered by the International Law Commission as a tool to prevent the fragmentation of international law. Therefore, the use of Article 31, paragraph 3 in a reasonable manner by the tribunals will help ensure that the law of the sea is in harmony to help prevent the fragmentation of international law, or will help to defragmentize international law, if you will. And I think it will also contribute to dispelling any lingering skepticism about specialized dispute settlement bodies. So at the infancy, when ICLOS was initially set up, there were a lot of criticism about having a specialized dispute settlement body for law of the sea, saying that it will make law of the sea detached from the body of international law. And I think the use of applicable law will help dispel these skepticism. On the other hand, I think there are 2 points that also need to be borne in mind. The first is that the use of external sources should always be considered taking into account states' consent. So in the cases mentioned, the external treaties to which the tribunals refer were also treaties to which the parties to the case are parties to. So the reference to these particular treaties might not have been so controversial. However, in cases where this is not the case, then the tribunals would have to tread with more caution. And similarly, when the rule of reference is being used, when the external instrument being referred to does not enjoy the same level of acceptance as COREX, then the imposition of these external obligations on unclosed parties by virtue of the rule of reference might raise some eyebrows. And finally, in the interest of transparency, I think the international courts and tribunals would be advised to be transparent in their legal reasoning, specifying or making clear the legal basis for resorting to external sources. And this will help ensure the reputation of the tribunal, as well as ensure that it contributes to the development of international law. And with that, I conclude my presentation. Thank you very much for your kind attention so far, and I look forward to the discussion.